All right, welcome to the August 21st EOTC meeting. This meeting is now called to order. Clerk, if you can call the, is there any agenda changes? All right, you can go ahead and call the first item.
Roll
or the
call.
roll. Sorry.
Roll call. Chair Wolf.
Present.
Bruce Wolf.
Present.
We have a quorum. Item number 2, adoption of the minutes for the June 19th, 2018 Education, Outreach, and Training Committee meetings.
Move to approve the minutes.
All right, I'll second that. Is there any public comment on the motion to approve the minutes? Seeing none, go ahead and call the roll.
Chair Wolf.
Aye.
Member Wolf.
Aye.
The ayes have it.
All right, thank you. Next item, please.
Next item, public comment. Members of the public may address the Education, Outreach, and Training Committee on matters that are within the committee's jurisdiction but not on today's agenda.
Is there anyone that would like to speak in public comment at this time? Seeing none, go ahead and call the next item, please.
Item number 4, file number 18058, complaint filed by Deontay Walker and Tamara Reed against the San Francisco Municipal Transportation Agency for allegedly violating Administrative Code Section 6721 by failing to respond to a request for public records in a timely and/or complete manner.
Great, thank you. If Deontay Walker and Tamara Reed can go ahead and approach the mic, please. At a previous meeting, the Compliance and Amendments Committee has already found jurisdiction over this matter, so we will just be listening to the merits at this point in time. And I believe the procedure is 5 minutes, correct? Mm-hmm. So if you can go ahead and put 5 minutes up, and you guys will have 5 minutes to explain what brings you in here today. Sorry about that. 1 second.
So we went to SFMTA's HR department and we requested some items. When we originally went there, April 5th, we asked the person at the window for the information or someone who could assist us. A guy named Lawrence came out and helped us. He pretty much, after explaining what we needed and actually explaining what the situation was, he told us pretty much he couldn't help us, and that Deontay, who was at the time the employee for SFMTA, he explained to him he needs to go through his union, and he explained to him that he already did so, and he basically told him, I'm not going to help you. The next day, I sent an email to Donald Ellison, Derek Kim, Mike Helms, Sandra Ng, and a few others, with the request that we had asked for the day before, and just put it in a formal email saying, this is the incident we had with Lawrence. This is the information that we're requesting. We didn't get any response back. So on the 12th of April, I sent another email to the same parties asking for a follow-up. I explained, we've been waiting already over a week. We haven't had any response. And then on 4 days later, on April 16th, we got an email, the first email from Mike Helms, who replied. I asked him, we've been waiting already. How can we get some assistance? Where can we get this information from? He didn't reply back until another 3 days later. All he said is, I got it on the 16th. On the 19th, I resent the email asking, what's going on, what's the situation? And he said that he'll get the information. Can you tell me what you need again? So I explained to him the list of things that we needed. From that time, a couple of days passed, still some emails, no responses. I finally got an email back from him on like April 27th or so, and he said that someone from the Public Records Department will contact me. So I asked him where they were located. I went in physically on the 8th of May and met with a lady named Caroline. She explained to me that she was getting everything ready, but she needed an extension, I guess some code that they have. If you need more time, you have to give them within 2 weeks. And I explained to her, I asked for this April 5th, and she told me, well, they told me you didn't ask for it until April 19th. So I told her, well, I have it in documents. I have it via email. When I requested these things, she asked me to forward those to her. I sent her the emails, and then she told me, if you feel that they didn't comply in a timely manner, contact Sunshine Ordinance Task Force, and that's what I did.
Great, thanks. Anything else to add?
We still haven't received some of the things that we asked for. We've even sent out multiple emails. We've even gone back and forth to HR requesting things. We were told we could only talk to the HR director, Donald Ellison, and we've sent out emails to him on numerous occasions, and we still haven't received any responses. And, since Deontay is no longer an employee now, their response is, we don't have to give you anything. He's even requested information out of his personnel file, and still to this day, we still have not been able to get a copy of that. We've written that in email as well, and still to this day, we have nothing.
Thank you. I believe my colleague has a question.
Do you have a list of the items that you requested?
I wrote some of them down, and I was actually going over my emails again, but we asked for the AWOL policy and the definition to see if they actually had something within their rule book or handbook to say employees are binded by this. We asked for the MOU, which we did receive a copy. We asked for timesheets for all day shifts, switch repairs, as well as the supervisor. We asked for disabled workers policy on, if they stopped working or working, how that worked. We asked for the 7458 service test list. I asked for Deontay's workers' comp form that he originally signed. I asked for a copy of the one that was signed from his supervisor. We asked for Deontay's leaves that were in the system that SFMTA had. We also asked for his vacation, all of the times that he would have had prior to him being terminated, and we don't have anything.
Okay, thank you. We'll probably ask more questions in a little bit.
Okay, thanks. All right. Is there a representative from the MTA here to... Great. Thank you. We can go ahead and get 5 minutes on the clock.
Okay, I'm Don Ellison, Human Resource Director, and I have here Sherilyn Norona, one of our labor reps. She's going to... You want to speak first or you want me to? Okay. I want to let the commission know that our position is that we provided all the information that they requested. We rarely admit that there was a timeliness issue. Wasn't intentional. And it got integrated in what I would call an employee relations issue, where we were dealing with issues not necessarily about information requests, but about performance issues, previous interactions with staff, and so that's how I got involved. I actually happened to be walking by one day, and there was an incident going on in our lobby, and I was asked to intervene. So at that particular point, I advised them that I would be the contact. Any information they needed, and this was based on an employee relations aspect, any information they needed, I would be the direct contact, so anything, bring it to me, they would. Tamara responded that she was aware and that I would be the direct contact. So at that particular point, our position was that the information they needed, they would come to me. But getting back to the original thing, we were saying we responded to all their information requests, really admit there was a timeliness because we weren't sure at that particular time, or we didn't identify them as information requests. It was just part of their employee relations issues. But as soon as we identified them as information requests, we got a hold of our person and got the information to there, put it through our normal process, which is through the website on information requests so it can be tracked. So we believe that we responded appropriately to their information requests.
And do you have an explanation, or do you have something to say before we move into questions? I apologize.
Yeah,
Just to add on to Don Ellison, since the request was not made through the regular process for public records requests, which is through the website, we did not know it was considered a public records request. As soon as we found out, after consulting with our city attorney, we immediately gathered the documents and provided it to Carolyn Salaya, who then put it into the system and provided it to Tamara Reed and Deontay Walker on May 8th and May 10th.
Great. Thank you.
Thank you.
Quick question. So when you received this email, and I see this April 6th email, but that doesn't seem to be explicitly asking for the records, at least not the part of it that I have here. But when you received this email requesting these documents, you said that it wasn't clear that it was a public records request. What made it not appear to be a public records request versus some other, or I guess a request from an employee?
Okay, our response was based on their intermingling, or their interactions with the staff. So with this particular process, that, the complaints about the staff and the way they were being treated along with the information requests.
Okay. All right. Thanks. Did you have any questions at this point?
I have some questions that don't leave. So, is there there must be a regular process for personnel, grievances and incidents and things like that, versus somebody asking for personnel records of their own versus a sunshine request. So, the first two probably are pretty well formalized, right? You have certain documents that people have to sign for them and all that. Were any of those included with regards to this particular request for records?
I'm not. Are you saying like the personnel records? I'm not sure what the question.
I'm trying to discern, where the breakdown of why there was a timeliness issue is. So just so we can make sure that we have the correct information to present to the task force when they have the full hearing. So I just want to have some understanding so we can explain it to them as to how this request was received and whether it was through a formal channel like a grievance procedure or a request for personnel records.
I don't know if you...
So public records requests are usually submitted through the website. Because we did not receive it through the website, we did not know it was a formal public records request. Ms. Reed and Mr. Walker came in on, I don't know the specific date, like April 6th to come in. They spoke with my colleague, and then they submitted an email to my boss asking for the requested documents. And at that time, we did not know it was a public records request because they did not specify that in their email.
But you had not received a request like this through any other means, like through some other formal process that you already have set up through, the HR office or anything like that?
Not to my knowledge,
okay.
No.
And just for your edification, are you aware that there's no requirement that a person make a request, a sunshine request, on the website? They can make it verbally or they can make it in writing.
Definitely aware of that.
Okay.
And again, as I say, I got into this process late and only as a personnel matter, and there was agreement that we would meet directly to deal with these particular issues.
Okay. And so now can you explain, so do we have all the documents that they requested? I mean, or are there documents that you are withholding? We want to try to make sure we have all the information to build the record.
So the documents that Ms. Reed requested, the time cards for all SFMT employees with job code 7458, list of persons who took the civil service test for job code 7458, and the absence, the AWOL policy was provided to them on May 8th and May 10th by Carolyn Salaya.
AWOL, absent,
Absence without official leave policy.
Okay. And is that all they had requested?
Yes.
To your knowledge?
Yes,
Okay,
to my
thank
knowledge,
you.
yes.
Thank you.
So I finally found the original narrative where it requested documents after they went and asked for them in person, and I'm curious whether your department has had a chance to read that narrative. It starts on page, I think, 47, and continues to page 52. This was essentially the original request for documents. It's a letter that was attached to the email on April 6th.
I don't have page number. Oh, that one, okay, I can find it.
So my question, assuming you have had a chance to review it, is whether or not there's any inaccuracies in the narrative as you understand it.
Chair Wolf, I'm just reading on page 45. Just before that is listed.
Sure.
At the bottom, and it says Dante has encountered another issue with the MTA staff. This seems to happen every time he has contact with anyone. Okay, that wasn't necessarily in the...
That's essentially,
That's not for the request.
As
Okay.
best I understand it, the framing around
That's the incident. So, okay.
this letter. It's the sort of attachment to the letter, and the letter includes a narrative and some requests inside of it. And so my question is whether or not there seems to be, as far as you know, any inaccuracies in the narrative about what happened as described here.
Okay. I'm still reading it. The behavioral issues, again, I looked into those. There are some questions on the behavioral and the answers and how they were answered. Requests for them, send them back to the union, the information in the MOU, which also contains the AWOL policy. This is public records time sheets. You see anything? Yeah. And it's difficult for me to speak to it because I wasn't there. But per their request, I looked into, and again, it was more on the behavioral issues because I was letting them know we're going to provide the documents to them. So again, that was a look at the behavioral, but I don't see anything on here that I would say they didn't request.
Sure. I mean, I guess where I'm coming from is that some of this stuff is, actual documentation that needs to be looked up. But the AWOL policy, I don't understand why essentially someone coming in and asking to immediately look at a policy of a department would ever be problematic at all. And the suggestion that because they're an employee, they'd have less access than the public because they're also always the public sort of is a bit of a mind boggle to me. And I'm just trying to get to the bottom of why someone, whether an employee or a member of the public that's seeking a policy document, would be given this much of go here, go here, go here, and then leaves without being able to review that document.
Okay, and I'll speak to that. SFMTAs as an individual doesn't have an AWOL policy. That's in the collective bargaining agreements because they're slightly different. What determines AWOL when provided access to the MOU should have included the AWOL policy.
And why were they not able to provide to obtain access to the MOU before they left that day?
It was my understanding that they were given the MOU
on the day they came in.
I can't speak to that.
Do you have any other questions for the respondent at this point? If I can have the complainant come up, and we'll try to figure out when exactly they got what they got.
The MOU was given to us, I believe, from Caroline, and that was in May. When we left on the 5th or 6th, whatever day it was, we didn't get anything. We were basically dismissed, just like we were with the other incidents. And when we did receive anything, it was because of Caroline. After that, even stuff that was sent directly to him, we still didn't get. So that was really what it was. We didn't get anything except for what Caroline gave us. And at the time, whether it was May 8th or May 10th, I have emails from her on the 11th saying, here's the AWOL and here's the one other thing. But we have to talk to our attorneys to get the rest because of they have to blink out some stuff or something like that. But we got it way too late, pretty much. And I had even sent the email directly to Mike Helms, who is Sherilyn's supervisor, asking for the documents. I've sent him. He was the only person that responded before Donald Ellison got in the whole mix. And he is the supervisor for her department. And still, we didn't get anything from him either. We had to go through the Sunshine or the public records request. And, we didn't know what the process was, if we were putting in writing or whatever, but we went and did what we thought was right and sent in an email saying we need these things. And, we still didn't get it.
Great. So I'll get back to you in a second, sir. So at this point, it sounds like there's some documents that you're seeking that are you seeking those through the public records process, or are you seeking those through the employee-employer relationship?
So we had requested them originally for a couple of different things. He does have the employee relation thing situation, but this was never because he was, I don't know, if in trouble or whatever it is. We were asking these things because they were helpful to him. And we still didn't get those things.
Sure, and I'm really trying to parse out between what you have gotten, whether it came late or not at this point, and what you still don't have.
We only have the MOU. We have a copy of the civil service list for when he took it when he first got hired, and we have the time sheets or time cards. The AWOL thing, I'm not sure if we have that. We don't have the leave stuff we asked for. We don't have any disabled worker policy because obviously they may or may not have one of those. We've even gone to the civil service and asked if they have that, and they told us it should be in the MOU. We've gone to the union, Local 261. They still don't have that information either. Deontay's leaves and his hours that he had before he got terminated or whatever, we asked for that stuff, even directly through Mr. Ellison, who told us at the time that he would be the only contact, and still directly through him, he didn't give us that. So even if it was personnel or not, we sent in a formal request asking for this information, and he told us, we'll get it to you. We were even told at one point we will sit down and have a meeting about this stuff and other things, and we still to this day have not had a meeting.
Great. So it seems like some of the stuff that you're seeking, you may have access to through the personnel relationship that would otherwise not be public records because they're personnel records. That stuff, I would like to see you get access to, but it may or may not be within our jurisdiction.
Right.
This is just a sort of pre-meeting before we go before the full task force to really hash things out. But what I would like to see is a list of what you still haven't received that you've requested, so that we can sort of walk through that. It sounds like there is an acknowledgement from both parties that there may be a timeliness violation. The other thing that we really like to focus on is trying to get the people the documents that they're seeking, so that we can be not only about identifying problems but also fixing them. Right. And the easiest way to do that is to really make sure that whatever documents you haven't, that you don't have, you have already requested. So maybe pointing to where those are on the past documents, but most importantly, making the list of the things you've asked for and still don't have, okay, so that when it goes to the full committee, we can go through line by line each of these documents and why you don't have them. Okay. Anything else?
Not in relation to that. I just wanted to make sure we have the chronology, because they received some records at some period of time and other records at a different period of time. If they're all beyond the timeliness issue, that's of no consequence. But then the question becomes, did they get all the documents that they requested? and were any withheld, and if they were, for what reason?
Right.
If they're public records.
Great. And, sir, you had something to follow up with?
Thank you. And I wanted to add, again, I'll admit that I wasn't there, but, one of the things they said they didn't receive the MOU, and I'm reading from their records and saying we waited about 5 to 10, page 50, I'm sorry. We waited about 5 to 10 minutes from Lawrence to come out when he came out and gave Deontay the MOU. So in the statement about not receiving the MOU, in their own statement here, they're saying they did receive it. And you are correct on the personnel records. And so it's, yeah. We're prepared. Again, I'll admit there was a timeliness issue, and we're prepared to look at any other documentations. But again, the personnel and the personnel issues, you're correct. And I'm saying I think we're responsive with those as well. But again, that may not be within your jurisdiction. So.
Great.
All right. The only other thing I have, and this is really just for us, but I think would pertain to you too, since it's coming from your department. Carolyn Salaya is the Director of Public Records Requests. She's basically the Public Information Officer for the collection of general requests to the department, I guess. She made a statement that said, this was on May 11th, on the first time I see it is on page 21. She stated, the SFMTA has 10 calendar days to respond to a request to inspect or receive copies of records. In certain circumstances, the SFMTA may extend its time to respond by an additional 14 calendar days. That is not in the ordinance. There's nothing that allows for that in the ordinance. If a person is making a regular request, it's 10 days turnaround. If they're making an immediate disclosure request, you must respond by the end of the next business day as to whether you have the records, and if so, when they will be coming or what have you, but should not exceed 10 days turnaround. And if it's voluminous, you can then provide them on a rolling basis. Or if those documents haven't been created yet, but they're part of that subject matter, they would then come on a rolling basis. So that's the way it kind of works.
I will inform Caroline.
Okay. She's been here several times before, so I think she knows. But it was just odd to see it, so recently to see it or state it like that in writing. So, okay, thank you. And, Mr. Chair, I think we should notate that as part of the brief when we present it to the task force, the case of the task force.
I mean, we can, although at the same time, as best I can tell, we're dealing with April 4th to May 11th, so it doesn't matter which extension, it's still...
I understand. It's just that the misinterpretation by the person actually taking care of these for the whole department, I think it should be noted.
We can note that in the record, absolutely, and address it in the summary when we bring this before the full commission, just to reiterate that fact and make sure that the proper information is disseminating to our city departments.
Thank you.
Sounds great. We need a motion.
I move to, it's already been found to be in jurisdiction, right? Mm-hmm. So find the records are public, and to recommend it for hearing to the Sunshine Task Force.
All right, I will second that. Any public comment on the motion to find that... Wait, are we finding that all of the records requested are public, or because some of them may be personnel records?
Well, they're still public. The question, if they're withholding it because they're personnel records, they would need to cite some law or some code that allows them to withhold it or retract it.
All right, so there's a motion to find that the records are public and refer this case to the full task force. Is there any public comment on that? Seeing none, clerk, go ahead and call the roll.
Member Wolf?
Aye.
Aye.
Chair Wolf?
Aye.
Motion passes.
All right, next item, please.
Item 5, file number 18011, complaint filed by Denta Tedesse against John Haley and the San Francisco Municipal Transportation Agency for allegedly violating Administrative Code Section 6729-2 by failing to update the SFMTA website on a weekly basis.
Great, and before we begin with this item, I think it's important to identify that we did have a representative from the city attorney who mistakenly thought they needed to be here and was since excused based on the fact that it was determined that the named party was actually the MTA. All right, if we could set 5 minutes for the complainant.
Sure. My name is Dennis Tedessa. I've appeared here before. Before, I never had the luxury of how the process worked, or I didn't have it explained to me how this whole process works. But I appreciate the process, although I am so far disappointed in how things have gone. But I still have hope. I have hope in the process, that it's at least open, it's fair, and at least I can, I just want it to be fair, that's all. And I want it to be open to the public. I am the public. I've followed all applicable laws. I went out my way to make sure my service animal is actually registered as a service animal. She complied with all kinds of laws, spaying laws here in San Francisco. I went out of my way to make sure she's always leashed. She's always had a collar. What I experienced was buses passing me by, trolleys passing me by, just because of the breed of my dog and the color of my skin. I'm not a person that plays a race card. I've been here since 1985. I'm from Ethiopia, coming from Africa. We don't look at that in the African American perspective per se. But now I understand the African American perspective, because it's happened to me in the past 3 years. Again, first the breed of my animal. She's a pit bull. Then the color of my skin. There's no reason why a trolley or a bus would just pass me by without even asking if I had fare or if I had a service animal. I always have had a fare. I've always had a service animal. She's a service animal to me 24/7. I have been recently made homeless because of the same issue. From my housing, what I told the task force before, that it has everything to do with my housing, the Mayor's Office on Disability, my complaints to SFMTA. Everything's linked. It's linked to my housing provider. It's linked to the Mayor's Office on Disability, the guidance that they give them. I have FOIA requests that I've gotten from HUD. It specifically states between them and my housing provider, specifically saying that the Mayor's Office on Disability, the local police captain have our support. I was just arrested on Saturday because my service animal was not on the leash. On a bus. Expressly, the policy of SFMTA is as long as the animal is under control. She's always been under control. She was right between my legs. The driver said she has to be on the leash. Because of my past experience, I'm not going to budge, because next time it's going to be the muzzle. Then next time it's going to be, they're going to just pass me by. So I follow the rules. He calls the cops. Cops come. They put me in handcuffs. They take me off to jail, don't charge me with anything. I'm released at 1 o'clock in the morning. My animal's taken to animal care and control. This has happened 4 times since I was evicted in April of this year. I'm wearing the same clothes, because I was evicted. I get a court stay. I get a judge to sign the court stay for a week. I come to City Hall. I can't get in because of my service animal, to show the sheriff's officers that I have a stay. The very next day I'm locked out, and I've been locked out since. I couldn't even get my belongings, for God's sake. I can't even get my papers that I'm trying to defend myself in the eviction. I can't even get them. Can you believe that? This is happening. This is happening in San Francisco. I call the cops. The cops come, they say, write on a piece of paper what I need, and they will go with my housing provider upstairs to my apartment and get the things I need. Is that acceptable? That is not acceptable. It all has to do with the roots of my complaints. Every time I'm complaining, things just happen to me. The next time, it's either my dog is going to be killed or I'm going to be dead.
All right, if you can just stay there for one second, sir.
I'm sorry to be.
No, I understand that you're going through some tough times. As you probably are aware, you have a few cases in front of us.
Yes.
This one in particular is just about the SFMTA updating their website.
Yes.
And so the parts of the Sunshine Ordinance that pertain to the website are somewhat limited.
Sure.
And I want to know specifically what part of the website isn't being updated.
The part that they've found reason to ban me, they found the part that says the requirement for the service animal to be on your lap while riding on the exterior of the cable car. I have listed those particular notices. I have included into the packet, and it clearly shows that in 2013, 2014, 2015, and 2016 that was not there. The website, you can check the website by going to waybackmachine.com. It actually shows you the World Wide Web in a past date, and you can clearly see if you need more proof that was not listed on there. That particular rule that got me evicted or got me banned from SFMTA was only because of one thing. I did not have my service animal on my lap while riding on the exterior of the cable car.
And so that's now on the website, but it wasn't on the website when this incident occurred. Is that what you're suggesting?
Correct. And then also, I know exactly when it was put on, because it was put on in January 6, 2017. It reflected finally on the SFMTA website that indeed this rule exists, and it actually spelled it out. While riding on the outside exterior of the cable cars, you have to have your service animal on your lap, and it was actually underlined, making it even clearer. So it's just not a simple just rule out of nowhere. This is a major rule. It's a major rule that affects. It's affected me, obviously, because it was used to then revoke my privileges for 5 years for riding the cable car. So this is a major policy. Major policies should be updated. It was not updated. It was only updated until January 6, 2017. It was finally reflected on the SFMTA website.
And when was it that you had this experience on the cable car?
All of 2015, all of 2016, and all of 2017 and present.
Great. Thank you. All right, if we can hear from the respondent from the SFMTA. They were just here.
But that may have been for a different issue, just for that other issue.
Okay.
Yeah, there is a board meeting.
I see. All right, so...
Roberta Boomer is.
Did they send a notice that they were not going to be present?
I didn't hear anything. I just knew that Roberta wasn't going to be present. She emailed us.
She did?
She did. And said that she would not be able to make it.
Oh, okay.
Because of the board meeting.
Okay, because we have a requirement for some representative to show at committee meetings. Okay.
Member Wolf, you have any thoughts?
Well, I mean, I think it's Mr. Tedesco. Let me ask you.
Yes.
When you where? How do I put it this way? I'm just going to say it. Where's the proof that this was posted in 2017? This policy on the website.
There's no proof. They have not shown any proof because it wasn't listed.
How do you know it was opposed?
I know that because after asking for reasonable accommodation and not getting a response from SFMTA to have my service animal ride between my legs, not on top of my lap, and still following it until I got the response, which I never did, I then resorted at the very end. I even emailed Chairman Nolan, Tom Nolan, who years and years ago I actually had dinner, Thanksgiving dinner at his house. So I've never used that kind of, hey, I know so and so. So this is the first time I've ever contacted him for anything. I then emailed him. I said, can you please clarify this policy? They're telling me that I have to have my service animal on my lap. I know that is not their policy right now because I've had a complaint regarding this issue. I had a response from Senior Transportation Planner Virginia Rathke stating exactly what I know, not even mentioning this lap rule. And I just, again, please, can you please clarify if this rule exists? I got a memo, which I've included into the packet, from SFMTA with Cheryl Brinkman's signature, with Ed Raskins, the Director of Transportation, his signature, outlining what the policy is for service animals on SFMTA cable cars and buses. Nowhere does it say this lap requirement. So what I did next was what I thought was basically all I can do is to do a public protest. And so before I did this public protest, I just wanted to make sure that legally I'm covered by checking their website. So each day before I would go out and do this public protest, meaning putting her between my legs and refusing to put her on my lap, that ended up with my revocation, was I would take a screenshot of the website. So every single day I took the screenshot, and so I know on January 6th at 1:25 a.m. I took the screenshot. That policy was not there. Later on that evening, I believe it was at 8:35 p.m. That website, the website was changed to reflect this new rule on January 6, 2017. I then appealed that revocation. Part of the evidence that SFMTA provided me was this exact to my allegations that it did not include that this rule did not was not included on the website, was their own copy of the website, which actually says on the bottom of that date, it says 1/6/2017, exactly corresponding to what I know.
Is there a screenshot of that in the record?
Yes, sir. Yes, Chairman. And if not, I'm happily, I have it right here for some reason. And I've been having some technical difficulties also. I find out that, I mean, it's crazy, but I found, yeah. Sorry. So this is the first one. And yeah, there's a...
What I find interesting is starting on page 293. Okay, great. Okay. Page 293 is their log of...
Yeah, I've definitely included into the packet. It was part of their evidence packet. It just shows. It looks like it just shows like a page. Those that I gave you. Those are my screenshots from the website.
I get that.
Okay.
I'm just saying. Were you able to corroborate what you were taking in screenshots? To this listing.
It's the wrong year.
Oh, it's just 2017.
Wait.
Yeah.
On page, look, if you scroll down, page 296, it says in the right side column, it goes down to 2017.
So 2017. So I know for a fact that it was changed.
The rest of the record
on 2017, and also I've included into the packet in order for you to also just verify, just to see if 2013, 2014, 2015 is not there. You can go to Wayback Machine. You can go back to the website, and you can see that there's no listing. There's no rule.
Okay. Let me ask you something. So the department in their response to this complaint, to your complaint,
Yes.
on page 291, they state that, they give an analysis that the SFMTA website is 14,000 pages on the site.
sure, sure.
There have been over 1,000 updates published, and so on and so on. Is your complaint focused on just the policy that you are concerned about, or are you focusing on other documents, other updates?
No, I'm actually focusing on that particular policy because that particular policy is a major. It's not like it's just a. It's not a run of the day. Just a simple policy of like do not chew gum. This is a major policy. They should have the major policies updated on the website. As soon as it's available.
Okay, I just wanted to be clear because
Yes.
the way they put it, it sounded like you were talking about their entire.
No, not at all. Not at all. This is specific. It's personal now because this specific policy again got me booted off after all the press. After I kind of declined press reviews because actually I felt bad.
Your time.
I felt embarrassed for myself. Number one, for the privacy. Number two, there's a lot of good people at SFMTA who have who helped me in all my complaints, but they took that as a sign that I'm somehow trying to go over them or I guess you have your 15 minutes of fame, and I kind of I didn't use mine as well as I should have. But I'm coming from an honest place. I'm coming from a my intentions have been pure. I just wanted the right to have my service animal and myself use public transportation like anybody else is, and I was tired of people passing us by. I was tired of people telling me I have to muzzle her, telling me I have to do this, do that. It's led down to a really crazy road that I find myself, in a tent in Golden Gate Park without my belongings. But to the day I die, I'll say this is what happened. I want this to be a record of what's happening. I want this to be a something. It's people ought to know what's happening. If someone complains about something, and you change the rules and you keep on moving the goalposts, so that they can't enjoy whatever they're asking for or whatever they're saying that they have a right to. That's wrong. I have serious misgivings about how things have gone, but it's pretty awesome in this country that you still have the right to redress. You still have the right to ask for a FOIA request. Other countries, like where I'm from, Ethiopia, you couldn't come up to a committee like this and actually complain. So it's great. It's awesome that this process is available for me, no matter how frustrating and how emotional it's got for me. That's all.
So one last question, just for this particular complaint,
Yes.
not the ones we're about to hear.
Sure.
It sounds to me like really it's all about this one page that referenced this regulation and what day it was updated. Is that correct?
That is correct, and that is my complaint regarding this is.
And your thesis is that it was updated on January 6th, 2017.
I know it was because of the questions I asked prior to that, because of the website evidence that I know personally when I took the screenshots, and because of evidence that they presented at the appeal hearing when I appealed my revocation back in early I want to say March of 2017. They actually provided information that actually supports my my allegations that this website was only changed to reflect this particular rule. Again, if you board on the cable car sitting on the outside of the old historic cable cars, you have to have your service animal on your lap, and it was underlined. This never occurred prior to that date.
Great.
That's what I'm alleging.
So I have a lot of pieces that I'd like to deconstruct with the SFMTA, who's not here right now. So I think that
Sure.
unless my colleague sees anywhere to go, that we're ready to move this to the full committee, and we'll be able to ask the MTA those questions at that point in time.
Sure.
So I'd like to go ahead and make a motion that we have jurisdiction, that these are public records, and to refer it to the full committee. Is there a second?
I say, and that if you would just add that it's within our jurisdiction. Did you say that?
Believe I said that.
Oh, okay.
Okay.
I'm sorry.
You did.
No worries.
It's all
Take the vote.
floating.
All right. So is there any public comment on that motion?
I'll second.
Seeing none, go ahead and call the roll.
Member Wolf,
Aye.
Aye.
Oh, sorry.
Chair Wolf,
Aye.
we have
Motion passes. Great. And if we can just sort of, I don't know what the process is, but it seems like the way the complaint is currently written is a little bit less clear than we were able to refine it. So I don't know whether it's possible to like add an addendum, but really we're talking about a specific change of a specific page.
Yes. And
Pertaining to an updated policy.
yes.
Great.
Exactly.
Thank you.
Or a specific rule, which, yeah.
Yeah, I don't know whether they're going to call it a regulation,
Or-
a policy,
yeah,
a rule.
okay.
We'll let them put those
Okay.
words in the record. All right, go ahead and call the next item, please.
Item number 6, file number 18028, complaint filed by Denta Tennessee against the Sheriff's Department for allegedly violating Administrative Code Section 67.5 by restricting access to all meeting of any policy body in City Hall.
All right, if we can put 5 minutes on the clock. And whenever you're ready.
Okay. This is again going to the policy on having a leash on my service animal when I enter City Hall. I was told by sheriff's deputies on numerous times I cannot have my service animal off leash when I come in. I have told them that she's under control. They always refer me back to the mayor's office on disability. The notice that is placed on the desk at City Hall from the mayor's office on disability, the same mayor's office on disability that I had a complaint against regarding the same issue. So I don't know. The task force actually told me to go back and see who's responsible, go back to the city administrator. I did, Naomi Kelly's office. They referred me again to the mayor's office on disability. I got nowhere. I then went to Lori Mazzola, her office, and she told me that she just refers me back to mayor's office on disability. So everything goes back to mayor's office on disability. Like I told you again, this policy is wrong. I have provided, I believe, in this packet, although I did not know that these other items were going to be on today's agenda. To tell you the truth, I only thought it was going to be the SFMTA website issue, and I can definitely give you more details on what law I'm referring to. But it's a CFR. It's 28 CFR Code of Federal Regulations. 36.302 states that as long as the service animal is under control, if it's because of a disability or for the safety of the animal or the safety of the handler chooses not to use a leash, they can, as long as the animal is under control. Rosie has always been under control. She has always been there has been no issues with her barking, defecating, snarling, anything in her record. And also, more importantly, in all the times I've visited City Hall, I should be allowed entry as long as my service animal is under control. She is. I choose not to use a leash for personal reasons. There's also security issues. What I do is I take off her leash, her collar, before I go through the security line. I've experienced that I go through more checks if it beeps as a black man, which, you know, again, I'm not trying to, but this is my experience. This is my reality. I don't want to go through that. So I take off her leash. If I'm going to an elevator, I take off her leash because of how people's fears, how they move around when they see her. They're afraid. They can trip. I can trip. She can get snarled. So in order not to deal with that, I take it off. I put it back on. It's not like I take it off forever, but if I have the right to do that. I have the right to make that decision as long as, again, she's under control. That's what the law says. I am just asking for the law to be followed. And I've been denied entry numerous times. I've been actually made homeless because of this, you know, this very issue. Like I said, this is kind of separate, but it has to do with all this. I couldn't even show the sheriff's officers my stay from the court signed by a judge. I paid a week's rent. I can't show it to them. I even asked them for reasonable accommodation to come downstairs. They wouldn't. I had no idea then that the very next day I'll be evicted. That's what happened. That's what happened. And so, I mean, I don't know what else to say.
Right. Thank you. All right. Is there a respondent from the Sheriff's Department?
Good afternoon. I'm Mark Nico.
1 second. Let's get okay, we're good now. Go ahead.
Hi. I'm Mark Nico, NICCO, Legal Counsel for the Sheriff's Department. Good afternoon. This is an issue really not about what Mr. Tedesse's claims are with regard to whether I can come in to the building with or without a leash. It comes down to what are the building rules. There's going to be no special exceptions. There's going to be no special rules for individuals with animals other than what the building rules say, and that is animals need to be under the control of their companion. They have to be on a leash. That's what the rules say. That's what the Sheriff's Department enforces. The first claim that Mr. Tedesse provides is that he was unlawfully denied entry to a public meeting. That's what the Sunshine Ordinance 67.5, I think it is, goes to, that meetings have to be public. There was nothing about the meeting that Mr. Tedesse was going to that was not public. The only claim that Mr. Tedesse has is that he was not allowed entry to the building because he was not following building rules. That is not an unlawful violation of his right to go to a public meeting. He was not properly following building rules, which are required by everybody who enters the building. San Francisco Sheriff's Department is entrusted to enforce the building rules. They are posted at the entry. I've given copies to the task force to review. Mr. Tedesse saw these posted rules on this time and previous times, it sounds like. He also admits, and you can see on the video when one of the deputies is speaking with him, that he was advised on previous occasions of this rule. It was Mr. Tedesse who doesn't believe this rule applies to him. Whether the rule is legal or not legal, according to Mr. Tedesse, it is really not relevant at this point. Whether or not he refused to follow the rule is relevant. It was a City Hall rule. Our deputies were entrusted to enforce that rule. That's what they did in this case. If you watch the video, they did it in a very calm and respectable, professional manner. He knew what the rule was. He refused to follow that rule. Unfortunately, the rules are applied to everybody who enters this building, and there aren't exceptions depending on who you are. Claim number 2, Mr. Tedesse does claim that the actions of the sheriffs in this case were ethnically motivated and motivated by his ethnicity. In this case, there's absolutely no evidence of that. It's pure fiction. There is nothing in this video, nothing about the interaction that would give rise to any credibility to that claim. I think it's an insult to the officers and deputies who responded to this incident, and it's an insult to the department as a whole to claim that with no evidence to support that. I think in the end, what we have here are deputies enforcing the building rules. Mr. Tedesse refused to follow those rules, And the only result of that refusal, he was not allowed entry to the building. That was his choice. If he wanted to attend the meeting, he had alternatives to do that. I noticed one thing that he said today that I wasn't aware of, that he says he only wanted to take the leash off when he enters the building or goes into the elevator. That was not clear from the video. That has never been presented. The only information that I've obtained in researching this issue is that Mr. Tedeschi was refusing to leash his animal at all in the building. So I think what we have here is just an enforcement of building rules, and I don't think this should be forwarded to the committee.
Great, thank you. One quick question. You stated that this is the enforcement of those building rules. Do you know who makes those rules?
I believe it is the administration, and this specific rule is by the Mayor's Office of Disability.
And in the event, you suggested that whether or not the law is lawful is outside the scope, but in the event that a law were to be created regarding building over crowd management, or however you want to frame the inflow outflow of the building, what would be the sheriff's response if it was in the eyes of the sheriff an illegal rule that the building...
Absolutely. To respond to that, if the sheriff believed that there was an unlawful order, an unlawful rule, of course we would take that up with the city attorney to determine the lawfulness of those actions. The sheriff is not going to not follow a proper lawful order or follow a known law. This rule, and to my experience and my discussions with the city attorney's office, has been vetted and is proper under the law.
All right, thank you.
Mr. Nico, I have a couple questions.
Sir.
So you're the chief counsel for the sheriff's office?
Yes, sir.
Okay. Are you familiar with the Americans with Disabilities Act?
Portions of it, yes.
So I just want to know and I'm not a lawyer, I do this as best as I can to understand these things. I just would like to know, is San Francisco is required to comply with the ADA in its public buildings? Actually, in its public buildings, not ADA per se, but Title 504.
I'm not an expert in this area. I do know portions of general laws. I think your question would probably better be presented to the city attorney who's reviewed the intricacies of ADA laws.
Okay. I'm just, because what I'm concerned about is, it's not the Sunshine Act that holds this particular law. It's the Brown Act. It's state law, right? So the state law requires that all meetings are to be accessible, open, and public access. So, for instance, if a public meeting was being held, say at 1 South Van Ness, which is not a public building, but we have public departments in there that have public meetings, they can't necessarily block access because it's a private meeting. For that public meeting, they must allow anybody in, and within reason, like we have metal detectors and things like that.
Sure.
But with regards to ADA or Title 504 for access of people with disabilities, specifically with service animals, now service dogs pretty much only. I'm just wondering if there's an allowance for a state or a city to provide an extension or an enhancement to provide more allowance or restrictions to that law. In this case, under the ADA, there is no requirement to have a dog on a leash if it's under voice control, under control of its owner or its handler. And so here, there's now a restriction that's added for this particular building, and I don't know if it extends to any other public building like a library or a museum or something like that, that requires a short leash. Can you comment on that?
I can only tell you that I was not involved in the implementation or the research done on what the current building rule is, so I can't comment on what aspects of the ADA law, the broader ADA law, was reviewed to determine the building rules. I can only tell you, as I said before, that my understanding in my meetings with the city attorney is that this does comply with ADA law, and that the building rules were created with those laws in mind.
Okay. All right. Thank you very much. I don't think I have any other questions. anything else to add to that. That would really be my only question at the task force at the same time.
Would be
if the ADA, or I don't know which law now governs government buildings. Title 504 was the one that came before the ADA for public buildings, and then ADA came for everything else, all private, establishments. So, but either way, for either one, the rule is pretty much the same. So I'm just wondering if the addition of requiring a short leash, what defines a short leash? So if you go, for instance, if you go onto the beach, the National Park Service has a rule that says you must have a dog on a leash no longer than 5 feet. Doesn't describe it as being short, long, or medium. It specifies specifically how long that leash is. So a short leash can be considered 1 foot, and in the case of now a precedent, it could be considered 5 feet because there are leashes that are 20 feet long. So I would just like to get some clarification as to whether, as part of the legalities for access into a public meeting with regards to service animals under ADA or under Title 504, whether the additional restriction of having a dog on a short leash is compliant.
So, in your own personal experience, are you aware of whether or not the 5-foot leash law in national parks applies to service animals?
It applies to all dogs.
Including service dogs?
No, it does not include service dogs. It only includes pets, dogs that are not, all dogs not service animals.
So this is not an example of an exception this is an example where service animals are exempted from a law that appears to be parallel to
as long as
the buildings law.
But the service dog would have to be performing its duty. It couldn't just be running around recreating. Okay,
right, but in this case, no one's refuting that the complainant's dog is a service animal.
Right.
The only issue is whether or not a law that says that a service animal has to be on a leash is lawful when it seems to not conform to the disabilities laws that exist.
That's my understanding.
And so I think that's the entirety of this that needs to be scoped out. In some ways, the source of the law or the source of the rule is possibly the person that we should be dealing with, and not the sheriff that is just following that rule, although just following orders is obviously not excusable, as pointed out with other orders that if they were unlawful would need to be looked at. So
I have a question for us as far as process. Should we suggest to the respondent to bring such information, or should we have our own legal counsel research that and provide it?
I mean,
because it's just a question of law at this point as to
I think we should probably ask both our legal counsel and the respondent to, explore the legal issues, because they may not see eye to eye, and that's the nature of our legal system.
Okay. That sounds good to me. All right. I have no other questions. This is pretty straightforward.
Given that this is sort of an informal process and we want to have everything tightened up, did you have a question for us that you wanted to?
Yeah, it's just not more of a question, but the Mr. Nico said that I refused to comply with the law. No, I did not refuse to comply with that particular rule because I never came in. If I came in, then I would have refused that and I would have completely ignored that. I would have been arrested or whatever. I did not. I actually obeyed what they said. I said, although I disagreed with it, I full-heartedly disagree with it, I did not refuse to follow the rules. I did actually follow the rules because I never went into the meeting, number one. Number two, a reasonable accommodation is central to what ADA law does and performs for disabled people. I am in a protected class. There are many examples of animals, say a person with a wheelchair. They might not be able to actually hold a leash. As long, again, it goes back to as long as the animal is under control. I also would probably refer you to what the Mayor's Office on Disability said when they came here last time. They said that she was out of control, which is a complete lie. She was not out of control. That's why they said that they only offer guidance to these departments. Obviously, that does not seem like guidance. Mr. Nico specifically said that he got that rule from the building rule came from the Mayor's Office on Disability. They're the ones who are making this rule. They're the ones who I initially said were responsible for this issue of me not being able to attend. I did not refuse that rule. I actually complied with what the Sheriff's Office said. My compliance with their rule, which they say is the Mayor's Office on Disability, led me to not attend the meeting. I was following the rules. I was not allowed into that public meeting. I asked for reasonable accommodation. I did not get it.
Thank you.
Yeah.
All right. Member Wolf, do you have a good way to wrap this up in a motion?
I would just say we find the complaint to be within the jurisdiction and that we request both the respondent and our Sunshine Task Force legal counsel to provide we call it research.
Legal brief.
What would you call it?
I mean, research or to brief us on it, either.
Yeah, provide advice, or we want to know if the ADA or I would say if the
It seems like there's
the law that government buildings must comply with are allowed to extend or enhance the law regarding service animals.
Well, it's not extend or enhance; it's to further restrict.
Or
Actually,
further restrict. Okay, so what I mean by extend is to be more kind of neutral.
But it is a restriction.
Okay, to further restrict, that's fine. Okay, you could state it that way. To further restrict, to place further restrictions on existing law. And this would be federal law, not state law.
Motion, gentlemen?
So will that request be written and provided to
Right, for when it comes to the hearing, because this is just a pre-hearing, before the trial. It's like a hearing before a trial. So this is so what we're doing is we're just trying to collect as much information as possible so that the task force members have as much information to be able to make an informed decision without spending a whole lot of time trying to research it on the fly. So
to be a specific request.
right, this is just kind of discovery.
And just before you sit down, sir, is the way that Member Wolf has described what we're looking for up here to conform with what you would know to present? I mean, as you yourself are a lawyer, it seems like you'd have a bearing on whether or not our request actually conforms to the lines or if we've framed it in a way that needs to be flushed out
If I can
further.
paraphrase it, you're asking whether or not the building rules are consistent with ADA law, or whether the building rules impose a separate restriction that's not contemplated by ADA law.
Correct.
Okay, and I think that can be answered, and I think our building rules are consistent with ADA law. I'm just not an expert on that. I don't know the specifics of the ADA law to tell you that. I just know my discussions with the city attorney and reviewing parts of the ADA law that are being referred to, that I think that the building rules are consistent with that. I don't think it's good to assume that requiring a leash, even for service animals, is outside the parameters of the ADA law. If you're making that finding, I think that needs to be made specifically clear.
Right, and I think we're looking for the legal argument for why you express what you just did, the legal backing behind it. Is that?
Yeah, we're not going to try to predetermine anything or presuppose anything. We're assume us not knowing and educate us as to whether it's in compliance, to add the restriction is in compliance or not.
Okay.
Great. Yes.
And to that, again, I would respectfully for Mr. Nico to refer to 28 CFR 36.302/C/D and /F on the applicable the actual wording in ADA law that pertains to leashing and when it can and cannot be accepted.
And so just,
Yeah.
this wasn't explicitly in the motion, but I think it goes without saying that if you would like to put a legal argument into the record as well,
Okay,
arguing
okay,
why you feel the way you do, please do. I think the reason that we didn't incline to do so is that the complainant is not necessarily a lawyer and prepared to make a legal argument, but you certainly are in this case, and we have no intention to prevent you from doing so.
Okay, and I will, and I have not included a lot more information on these other complaints because, again, like I wasn't aware that they were going to be presented here today at this time.
Anything that you want to put down on paper about the incongruence between your perceived incongruence between the ADA laws and the building codes or the building rules.
And then also what I think is very important is to go back to the testimony of the Mayor's Office on Disability. And they actually clearly said in their past testimony that the only reason that they restricted me was they thought that the animal was out of control, and she never was.
So I remember being a part of those meetings, and if anything you want to prepare from those past meetings, feel free. But at this point, we're sort of squaring this up and shooting it off to the full committee at this point.
Okay.
Is there any public comment on that motion? I don't think there's any public.
Did you second it?
Oh, I second the motion. Is there any public comment on the motion? Seeing none, go ahead and call the roll.
Member Wolf?
Aye.
Member Wolf, aye. Chair Wolf?
Aye. We got it right this time.
Motion passes.
All right. Awesome. Next item.
Item number 7, file number 18012, complaint filed by Denta Tedesse against Lori Mazzola, City Hall Building Management for allegedly violating Administrative Code Section 67.5 by restricting access to all meetings of any policy body in City Hall.
Okay, so this is again.
1 second, sir. We got to put 5 minutes on the clock. But while we do that, is someone from the? Great. Thanks so much. All right. Do we got the 5 minutes? Great. All right. You can go ahead and start whenever you're ready.
Okay. So this is, again, a extension of the complaint prior to this. Based on what the task force instructed me to do was to find out who is indeed responsible for me not being able to attend the meeting. Again, I went to Lori Mazzola. I emailed her. I believe the packet is in the... or the email correspondence between myself and her is in there. Nowhere does it say that my animal was out of control. She actually mentions that I seem to be a little bit out of control, which I was upset that I can't attend the meeting. Again, I'm a law-abiding person. I did not refuse to follow the law or that particular rule, although I disagree with it, and I'm going through the process of making sure that this does not happen happen again, does not happen to another person, that this is corrected. Mistakes happen. We're not perfect. I'm certainly not perfect. I always carry a leash for Rosie. I've had my own, there's, in the past complaint, Mr. Nico says that he wasn't aware that I actually, the specific reasons. I just gave that to the task force just as an example of what can go through any particular moment of any particular day for me to say, you know what, I need to let go of this leash. I need to have my service animal without a leash or not. It's up to me again. And so, again, this comes back to, I went to Lori Mazzola, building management. She said she's not responsible, although she's the one who made the call to the Mayor's Office on Disability regarding this. She got advice from the Mayor's Office on Disability, and I was not able to attend the meeting. Again, I hope it's not on the record that I refused to follow this rule. I did. I followed the rule. I disagree with the rule wholeheartedly. This rule is illegal in my view, and I should have been able to attend the meeting because my animal was under control.
Great, thank you. All right, respondent.
Good evening, John Gavin with the San Francisco Real Estate Division, representing the city building management, Lori Mazzola. I just want to get clear that the complaint, it's a sunshine accessibility issues. That's what the complaint is.
No,
are we conflating?
The complaint is barrier to access to a public building or meeting where a public meeting is being held. Sorry? Same difference, public meeting.
But the complainant was permitted to go into said meeting had he put the leash on the animal.
Right, and his question is that if he didn't put the leash on, that he would be prohibited
Can we
from
stop
coming
time,
to the
please?
meeting.
Because this is back and forth, not...
He would be prohibited from coming into the meeting, correct?
Correct, per the building rule.
Right, and so
after consulting with the Mayor's Office of Disability.
His complaint is that that's not according to the ADA rules.
And can I just read the ADA rules that I
Okay,
have?
so you can have, we're providing you 5 minutes to
Sure.
present your case, and then we'll ask you a bunch of questions after that. So let's continue with this process.
So after the sheriff's back and forth with the complainant, he came into the office to speak with Lori Mazzola to get more clarification on the rule and his disagreement with the rule. And Lori said those are the rules. The dog can come in if it's on leash. And that was in consultation in real time with the Mayor's Office of Disability, is my understanding. Just quickly looking up the ADA rule on service animals and leash. The question is, do service animals have to be on leash? The ADA requires that service animals be under the control of the handler at all times. The service animal must be harnessed, leashed, or tethered while in public places unless these devices interfere with the service animal's work or the person's disability prevents use of the devices, which the complainant clearly said he does use the leash and has a leash. In that case, the person must use voice signal or other effectives, but he clearly stated that he does use a leash when needed. A person who uses a wheelchair may use a long, retractable leash to allow the service animal to pick up or retrieve items. The complainant's not in a wheelchair. I think this should not go forward because had the gentleman used a leash, he would have been allowed to come in. He's not claiming that the service animal doesn't need a leash. He's saying he carries a leash. He doesn't put a leash on it at his own discretion. And that's just something that I think we can figure out here, and I don't think we need to move forward with this at full Sunshine Task Force Committee. That's really all we have to say. The the actual rule was put in place in consultation with the Mayor's Office of Disability, and by no means is the building management at all trying to discourage anyone from coming to a public meeting. We just want all people of the public to abide by the rules that are set in place and that are prominently displayed at all entrance and exits of the building. And I'm happy to answer any questions.
Great, thanks. Just as a point of clarification, this came up in the previous hearing. This committee process is to sort of untangle and help things move forward, but we aren't in a position to find a violation and be done with it, or to dismiss a complaint and be done with it. This is a process to, yes, exactly. Thank you.
It's just discovery.
Okay, I misunderstood when you said it's within your jurisdiction or not.
Oh, no, what we determine here, the task force gives the committees that are hearing complaints the authority to find whether the complaint is within the jurisdiction of the Sunshine Ordinance, Brown Act, California Public Records Act. If it's under some other law, then the committee can make that determination and dispense with the case.
Right, and I think just my opinion that it's kind of conflating the Sunshine Law with ADA.
Actually, it's not, because the Sunshine Law requires that meetings be open and accessible and there be no barriers to people's entry. So if there is some existing policy that is preventing entry and that is in conflict with some other law, then the question is the law that's providing the restriction in conflict with the Sunshine Ordinance? And if so, then the Sunshine Ordinance takes precedent.
And those matters are typically not what we think of when we use the term jurisdiction. When we use the term jurisdiction, we're usually looking at whether or not the entity is under the Sunshine Ordinance. So, for example, if you filed a Sunshine complaint against McDonald's, we have no jurisdiction over McDonald's. End of story.
Okay. And so, I guess in closing, I was trying to express that I do not see that building management created any barrier whatsoever. They gave the opportunity for the individual to put a leash on the dog, and he carried a leash.
Right. So we're not going to argue the case here, and that we're going to leave for the rest of the time when all 9 or 11 members are here when we have the regular hearing. We're just trying to collect the information, make sure we have all the information that you want to provide. If there's any information that you didn't provide before that you want to add to the record, and then we just make sure that the record and the case file is complete enough so everybody, the task force, has enough information so they can, go right on, carry the case without any further question at that point.
And what was the source you were reading from earlier? You were it sounded like a Q&A about what the ADA requires, and I'm trying to figure out what your source was.
ADA.gov.
And so it was a Q&A.
U.S. Department of Justice, Civil Rights Division, Disability Rights Section, ADA.gov.
But it was like an FAQ that you were reading from?
And it was part of the FAQs. Correct.
Great, thank you.
I have no other questions.
All right, thank you.
Sure.
Do you have any questions for our complainant?
No.
You prepared for a motion at this point?
I am.
All right, well, go ahead
and move to find in jurisdiction, and same instruction as before for the previous to
ask them to brief the potential legal conflicts and what should take precedence between the leash law and any existing ADA law. Right. Great. I'll second that. There's no public.
Roll.
Go ahead and call the roll.
Member Wolf?
Aye.
Member Wolf, aye. Chair Wolf?
Aye.
Chair Wolf, aye. Motion passes.
Great. Next item, please. So thank you. We will go ahead and schedule an update or a follow-up hearing with the full commission. Are those the only 3 cases that are before the task force?
There was the one about the city attorney and the privacy issue, and I found more information in terms of pertaining to that in the Brown Act that completely that I feel would support my case. That was the only other one that did not go forward.
So it'll be up to the chair and our staff to determine when they're scheduled, but we may end up doing the preliminary on that one beforehand. That's not up to me, but we'll just have to see how that moves forward.
And if you can just please email me. I don't have access to my phone. It was locked in my apartment. I'm living in a tent in Golden Gate Park. So if you can please do that. And if you can also find, Victor is very nice enough to be watching my dog right now. But if you can find some way I can have her inside here while, again, respecting my wishes about the leashing issue or creating some other. I've tried to go about this accommodation.
So until we can
rule on it,
rule on this, there's no way that we can.
So I'll try to have her at a friend's place and.
Yeah, we don't control the building.
Okay. So to whatever extent, when it's not crowded, you are comfortable having her on a leash does not in any way legally invalidate your right to not have her on a leash. So, there may I'm not in any way suggesting what you should do, but I am saying that if you decide to bring her in on a leash, doesn't in any way make the case that you shouldn't be, it doesn't invalidate your argument.
Okay, that's how I'm feeling. That's one of the reasons I'm very.
I understand, and I can certainly empathize with why you're coming from that angle. But from a legal perspective, the fact that you are willing to make allowances that you don't feel you should have to doesn't set a precedent that those allowances have to be made.
Okay.
Perhaps other people would disagree with me, but that's certainly my understanding.
No, I don't disagree. Just because you decide to comply in one or more
because then they'll
cases,
say, well, you did it this time. Why don't you do it the other time? But they don't know.
That's not part and parcel of your complaint. So
Okay.
That just allows you access so that you can effectuate what you want to do.
Okay.
So that way in the future, if it comes to pass that the law finds in your favor, then you'll be able to.
Okay.
That's your whole purpose here, right?
Okay, yeah.
Then to these documents, I'd like to copy them if you want to come by tomorrow to pick them up.
Yeah, sure. Thank you. And I'll add more into the packet. Thank you for your time.
Great, thank you.
Thank you.
All right, next item, please. Next item, please.
Next item is adjournment.
Move to adjourn.
It is 5:34.
Meeting adjourned.
Interesting here is it gives this example of a returning veteran who has PTSD is great. Can you turn off the microphones, please?
I'm sorry.